In the complex world of family law and vexatious litigants, one case stands out. Today we're diving deep into the legal maze of Ms. Spencer's 23rd appeal attempt in the Federal Circuit and Family Court of Australia, a case that pushes the boundaries of family law. It's a fascinating study of persistence, legal intricacy, and the relentless pursuit of justice. Our story begins with Ms. Spencer, who sought leave to appeal after the dismissal of her application for parenting orders. It was her 22nd application under Section 102Q of the Family Law Act, all previous attempts ending in dismissal. Ms. Spencer, a name that has become synonymous with persistence in the Australian legal landscape, was seeking parenting orders once again. However, this time, her application was met with a dismissal that would spark her 23rd appeal attempt. Each of her previous attempts had been rejected, deemed vexatious, and without reasonable prospects of success. This latest application was no different, dismissed by the primary judge who deemed it vexatious. The judge's decision was based on the lack of new evidence or compelling arguments that could potentially sway the outcome in her favor. Ms. Spencer's relentless pursuit of a favorable verdict, despite the numerous dismissals, has made her a vexatious litigant in the eyes of the court. The primary judge's refusal was based on a vexatious claim, one lacking reasonable prospects of success. The heart of the matter lies in Ms. Spencer's allegations of bias against the primary judge. She believes that the judge's past professional relationships influenced the decisions made, leading to an unfair outcome. She's convinced that the scales of justice were skewed and not in her favor. Now, bias is a serious claim in any court of law. It can undermine the very foundations of justice if proven. But that's not all. Ms. Spencer also contends that her concerns were brushed aside too casually. She had raised issues about her child's school change, expressing fears about the potential impact on her little one's life, but she felt unheard, her concerns lost in the legal labyrinth. And then there were the family animals. She alleged mistreatment, a claim that was dismissed outright. To her, it felt like a dismissal of her feelings, her fears, and her fight for justice. Furthermore, she asserts her concerns about her child's school change and allegations of mistreatment of family animals were unfairly dismissed. To make sense of this legal puzzle, we turn to the rules. The cornerstone of this case is Section 102Q of the Family Law Act, which defines a vexatious proceeding. This section, along with its siblings, 102QF and 102QG, outlines the grounds for dismissing an application if it's deemed vexatious. Another key player in this legal drama is the Federal Circuit and Family Court of Australia Act 2021, which informs the court's decision-making process. Now, let's see how these rules were applied to Ms. Spencer's case. The court found her bias allegations lacked substance, as she failed to demonstrate actual prejudice. Her new evidence didn't significantly challenge the primary judge's conclusions on the impact of the school change on the child. Moreover, her allegations of professional relationships influencing the judgment and claims of animal mistreatment lacked logical coherence. Thus, the court's application of the rules led to the dismissal of her appeal. In the end, the court dismissed all bias claims and deemed her appeal vexatious under Section 102Q. The application for leave to appeal was denied. The court's decision was based on a thorough analysis of Ms. Spencer's claims and the applicable laws. The crucial turning point was the lack of new, compelling evidence and the repetitive nature of her applications. Her claims of bias were dismissed as they failed to provide any concrete proof of actual bias, merely relying on assumptions and past professional relationships. The court found that her concerns about her child's school change and allegations of animal mistreatment were not significantly different from the issues raised in her previous applications. Ultimately, the court's reasoning was clear and grounded in the rule of law. An unsuccessful application doesn't automatically imply bias, and past professional relationships do not inherently indicate a conflict of interest. This case shows that an unsuccessful application doesn't imply bias, and professional relationships between legal professionals don't automatically indicate bias. And there you have it, the case of Ms. Spencer. This saga of 23 appeal attempts underscores the importance of solid grounds and new material when alleging bias. It reminds us that repetition isn't a substitute for new, compelling evidence. Ultimately, this case serves as a beacon illuminating the path for those navigating the intricate labyrinth of family law. Remember, in the world of law, facts, rules, and reasoning are your guiding stars.